name is Deb Ellsworth from the Foundation of Adult Learning class, and I'm here today to talk about my research paper, Life Support, The Challenges of the Patient Self-Determination Act. Begin with the end in mind. Most people, when they hear this phrase, they think about planning a big project or a big event, but rarely associate it with planning the end of their own life. However, over the years, medical science has advanced to the point where they can sustain a person's life well beyond the constraints of a catastrophic medical event. This has left medical providers and family members stuck in a place where they're not sure whether to sustain or withdraw life-sustaining treatment because the patient's medical wishes were not made clear. This has led to many court battles over the years and a lot of agony and pain for both medical providers and for families. In 1991, Congress passed the Patient Self-Determination Act. The goal of this act was to empower patients to create advanced medical directives stating what their wishes were should they become in a position where they could not speak for themselves. The second goal was to reduce overall health care costs by giving physicians and families a directive as to whether to sustain or withdraw treatments that the patient may not want. Advanced directives are the center of the Patient Self-Determination Act. Advanced directives are a written documentation of what a patient's wishes are regarding medical care in the event that they become incompetent or incapacitated. They're usually signed by the individual when they are competent and then brought out when that situation changes. There are three basic types of advanced directives. The first type of advanced directive is known as a living will. And a living will is a written document, usually produced with an attorney or a medical physician, and it states what type of treatments or procedures a patient may want regarding their care should they become incompetent. Items such as cardiopulmonary resuscitation, artificial ventilation, and artificial hydration and nutrition are usually addressed in these documents. The second type is a durable power of attorney for health care. A durable power of attorney for health care is another document that states which person a patient might want to make medical decisions on their behalf should they become incapacitated. And the third type is a medical code status. These are usually documented upon patient admission, and they are only good for that admission. They can change from patient admission to admission, and they state whether or not a patient wants to have full medical care, which is known as a full code, or restricted medical care or no medical care in the event that their heart stops beating or they stop breathing. The Patient Self-Determination Act set forth many requirements for states regarding their laws on advanced directives. They were required to review their laws and document them in some type of written form that could be given to patients upon admission to a medical facility or a hospital or a nursing home. These documents were to advise patients of their rights under the law and define advanced directives laws in their state for those patients. The second thing that medical facilities were required to do was to keep documentation of their own policies under the law and keep those policies updated in accordance with changes in the law. They were also required to educate the staff and public on their rights under advanced directives and document directly on the medical record whether or not an admitted patient had an advanced directive in place. Also, medical providers were advised that they could not discriminate health care decisions based on the existence of an advanced directive. States were given great autonomy in writing their laws regarding advanced directives. However, a few loopholes were left in the system with this autonomy. One issue that was not consistently addressed throughout the states was patient competency, with only 6 states specifically defining what makes a competent patient as part of their laws regarding advanced directives. Another issue that was not properly addressed uniformly across the states was the issue of who could be a medical healthcare proxy for a patient who is incapacitated. Some states automatically deferred to the family as the medical proxy for a patient without advance directives. Some states said the proxy could either be a family member or it may not be a family member, which was quite ambiguous and left a gray area in determining who should be responsible for this patient's care. There was one state, Oklahoma, stated that only a court-appointed medical proxy could make medical decisions for this person. The court-appointed proxy may or may not be a family member or someone who even knows the patient. There are also issues in the law to be addressed regarding communication. Currently, under the law, communication is required to be given in written form upon admission to the hospital. During these situations, patients are often under medical distress and receiving a lot of other documentation in relation to their admission to the hospital, and it is not the optimum time to be advised of their rights under advance directives. In fact, it was shown in a recent study that when patients who had scheduled hospital admissions were sent information on advance directives in advance, completion rates of advance directives increased by 40%. There are also something called an advance care planning conversation. This is when a medical doctor and a patient sit down together and they have an actual conversation and write up the patient's wishes. This is a one-on-one conversation and a great way to properly document what a patient would want in the event they became incompetent. It was actually written into the original Affordable Care Act law that providers could be compensated for having these conversations with their patients. However, this provision was struck down in the final version of the law. There are some promising statistics surrounding the progress of the Patient Self-Determination Act. A study was conducted in 2014 by Sivera, Watala, and Piette, and it looked at a group of 6,000 patients over the age 60 who had expired between 2000 and 2010. In the study, they first looked at what percentage of the patients had advanced directives completed prior to the time of death. That number rose from 52% in 2000 to 71% in 2010, showing great progress. However, they also looked at whether or not there was a decrease in overnight hospital admissions during that time as well, particularly in the last 2 years of the patient's life. This number actually increased from 52% in 2000 to 71% in 2010. This data suggests that there was not a direct correlation between advance directives being placed and an overall reduction in healthcare costs. The Patient Self-Determination Act has made great strides in educating the public about advance directives and their rights under advance directives. There are still ways to make this law better, and it could be improved through use of advance care planning discussions and creating a uniform state requirement to determine competency and who can be a medical proxy. Thank you.